Good day to you and welcome to another Paddocks Club tutorial. Today we're going to talk about access to sectional titles, owners' details, who, if anyone, can demand to see the contact details of owners. The tutorial is designed for owners, trustees and managing agents in sectional title schemes, and it arises from a question asked by Marcia and Sarah, a managing agent of Johannesburg. But it is a question I get regularly and one that often causes a problem in practice. Let's give you a quick overview of what we'll deal with. Trustees and managing agents are often asked for lists of owners with contact details. So is the body corporate obliged to keep owners and trustees' names and contact details? When must this information be made available? By whom? To whom? How quickly? And what are the logical questions arising? So we start off with the question, is the body corporate obliged to keep owners and trustees' names and contact details? Well, the first of two provisions that apply is Section 37(1)(l) of the Act. A body corporate shall perform the functions entrusted to it under the Act, and those include to comply with any reasonable request for the names and addresses of the persons who are the trustees of the body corporate or who are members of the body corporate. So that's names and addresses of trustees and owners, a statutory obligation. The second provision is Prescribed Management Rule 35(1). And here the trustees must keep proper records, and these include a register of owners showing their addresses. On the application here, a more narrow list of any owner, registered mortgagee or the managing agent. The trustees must make these records available for inspection. So let's go back on that. When must this information be made available? By whom, to whom, and when? Well, where Prescribed Management Rule 35(1) applies, as it usually does, yes, the body corporate's mandatory records must include a register of owners with their addresses. On application by any owner, registered mortgagee or a managing agent, the trustees must make these records available. This, in fact, is much narrower, as we will see, than Section 37(1)(l). So you really only need to look at that. Under Section 37(1)(l), when it comes to owners' details, it's the body corporate's duty to keep the owners' names and addresses, as well as that of trustees. And trustees must perform the body corporate's functions in terms of Section 39(1), so they must arrange for it to be done or do it themselves. And how quickly? Well, within a reasonable time, taking all the circumstances into account. Please bear in mind Section 37(1)(l) is part of the Act. It can't be changed by any scheme. So what questions arise from this? In Marcia's case, the owner has over the years tried to get owners' contact details and email addresses from them directly by going door to door. She says he's done this personally and for his own reasons. Many owners have complained to the trustees. Most were worried about their contact details being given out. In fact, the trustees were told not to give their details to anyone. The trustees agreed with the owner's conservative views on this one, and this owner failed to get the information, so he's now demanded a list of owners' addresses and all contact details. Well, what is a reasonable request in terms of Section 37(1)(l) of the Act? Then this is the question Marcia asks. It's a request by somebody who has a material interest in the scheme, such as an owner, a trustee, a bondholder, or a managing agent. A person who has a real interest in the scheme that could be protected by direct communication with owners. And that's really what the whole provision is all about. The right to write directly to owners without having to go through a gatekeeper. Neither the trustees nor a managing agent is entitled to say, no, send it to me and I'll send it on. People have the right to, if their request is reasonable, to get this information, whether they want to talk directly to the trustees or to all the owners. And she asks, but is it reasonable if he wants it for his own purposes? Yes, indeed. An owner has a legal right to address communication to all his co-owners. By buying into a scheme, you are opening yourself up to communication from your co-owners. That's because the Act says that they're entitled to this information. And she asks, can we just give the unit numbers? Well, the short answer is no. You can't just give the unit numbers. This is information you could get from the deeds registry or from the local authority's valuation roll. That's not what this provision is about. Do we have to give him their physical address if they're not living at the complex? Yes, because the whole idea is that he should be able to write to them. You have to give the owner the address you use to communicate with that owner. But must we give all details? The answer is no. You don't have to give out every detail that the owner may have given you, emergency numbers, that sort of thing. Not at all. Just one valid address. The idea is that owners are entitled to be able to address communications to other owners, not to know everything about them and how many email addresses they have. When is a request unreasonable? When the person has no genuine interest in the management of the scheme, such as a salesperson who wants to sell something to all the owners. That is, that person has no interest that he or she might need to protect by communicating with other owners. I hope that this has been of assistance, and I look forward to chatting to you in the discussion forum.